Hi, this is Rahul Reddy. We are here live from Houston, Texas. Reddy Neumann PC brings weekly immigration news at rnlawgroup.com. Emily, what do you have today?
So today we wanted to talk about what options you have in the event that an I-129 petition is denied. So this would be for H-1B petition and L-1 petition. Those are the most common ones that use that I-129 form. What can you do? There's more than just filing an MTR or filing an appeal. We also want to talk about what we're seeing right now is denials of OPT applications. The actual I-765 application for some F1 students are being denied on technicalities that really could have been avoided. So we want to let you know what to look out for to make sure that you don't make those same mistakes if you are filing for your OPT or your STEM extension. We also have news on the lottery registration process for the H-1Bs that we are expecting to take effect for this coming April. We have a new announcement in the in the Federal Register about that. Wanted to go over a little bit of the last action rule to make sure people are aware of that and know when to take action after they receive an approval, or if they have, this often comes up when people have more than one application pending, to know which one is actually in effect once the approvals come. And lastly, we wanted to talk about a little bit more about H-1B approvals that we're seeing coming with less than 3 years, even though the person is eligible for the full 3-year period. Why is that happening, and what options you have to overcome that particular situation?
Emily, on the I-129 denials, I mean, there are multiple options for the people: motion to reopen, motion to reconsider, and appeal and litigation. Before we go into the next, I want to differentiate. When do you file the motion to reopen, and when do you file a motion to reconsider, and when do you file the appeal? We'll discuss about the litigation afterwards.
Right. So the important thing to be aware of about a motion to reopen and a motion to reconsider, those only go to the service center that denied the petition. An appeal goes to a different administrative body called the Administrative Appeals Office, or the AAO. So if you're filing a motion to reopen or a motion to reconsider, it does not go to a separate agency or a separate office. It goes right back to where the denial happened. And so a motion to reopen means that there is additional evidence available that could have resulted in a different outcome if you had the opportunity to submit it. So motion to reopen means you are asking them to reopen the case and look at this new evidence. A motion to reconsider does not provide new evidence. It's based more on legal arguments. You're not providing any additional documentation. You're just saying that the decision was legally wrong for whatever reason. Now again, if you file a motion to reopen or a motion to reconsider, it does not go to the AAO. So if those get denied and you want to appeal to another level, you have to file an appeal separately. The opposite of that, so if you file an appeal directly to the AAO, they will first treat it as a motion to reconsider or reopen at the service center. So you kind of get 2 bites of the apple if you file an appeal. So we rarely file MTRs unless it's a specific type of application that does not allow for an appeal. There are some things like a denial of an I-485 that you cannot appeal. Your only option is an MTR. But when you have the option to appeal, generally that's what I would go for over an MTR, because an appeal is automatically treated as an MTR first. So you kind of get 2 shots at it. So those are your basic options.
So Emily, let me explain. Motion to reconsider and motion to reopen. I mean, the only time when you do it is when legally it's not allowed. For H-1Bs kind of thing, I have I-129s, L-1s, H-1Bs, you do have an option to appeal. You don't have to just go. So you normally go for motion appeal, and it will automatically, the USCIS automatically treats it as a motion to reopen or reconsider.
Right.
And then they will rule on it, and once they they motion to reopen and reconsider, and they say, well, we're going to stick with the decision, what will happen afterwards?
Then the service center is going to forward the whole file to the Administrative Appeals Office, where they will take a second look at it. So that takes about 6 months from the time that it gets forwarded to the Administrative Appeals Office before they actually
So
look at
whenever
it.
the option is there for appeal, and practically you have no reason to feel that why a person should just file to motion to reopen or reconsider when they can file the appeal, because they're going to get this, two shots at the same thing. They're going to motion to get reopened, and if the officer wants to think and he's approval, he's going to approve the case. And if he doesn't think it's an approvable case, then he will send to the administrative appeals unit. So there's no reason for us to file a motion to reopen or reconsider when there is a chance for appeal. But of course, on student visa, OPT, STEM extension denials, and 485, we don't have an option of going to appeal. That's when we're going to go for the motion to reopen or reconsider.
Yep. And also like a change of status denial or an extension of stay portion of the denial. You can't appeal that. That can only be done by an MTR.
Emily, on the litigation option, I mean, when you're doing, this topic is more about I-129 denials. Of course, in your practice, you have filed an appeals. In I-129 denials, you have filed a lot of appeals. And in general, you watch the other people. You are part of the Immigration Lawyers Association. How many appeals get reversed? And don't tell me depends on, okay? Give me the statistics based on what you think so.
Yeah, I mean, the statistics are out there, and they say for I-129 denials, it's about only 3% of the appeals that go to the AAO actually get reversed. Everything else, they either dismiss the appeal or they sustain the decision and the denial stands.
3%. 3% of the time. So all the money and everything is for the 3% of the time.
Right.
And based on the cases, that within that 3%, you can make a judgment call, is that right, Emily?
Right.
And most of the time when we do file an appeal, I mean, a lot of pressure comes on with the client that appeal. But there are other alternatives. Sometimes if refiling is there, that's one option that you might have to consider, refiling the application. We will discuss more about litigation later on though, but if the refiling option is not there, for example, cap subject application, you can't just refile it, you have to refile it next year. So in those cases, people will tell appeal, but there are other solutions which we're going to discuss later on though. Appeal is not the only solution. Coming back to the litigation point of view, and we've been started recently, we used to get a denials of 2 to 3%, and now that has gone to 25 to, in some cases, 40% of the time. And our office is not immune to the bites of the USCIS. In the litigation aspects, what are the chances? You're telling 3% is for the appeal. And now we're getting like 25 to 40% of the H4 I-129s are getting delayed across the board, and that's a little bit more for the consulting companies. The litigation, what are the probabilities of litigation? And
the difficulty there is I don't have exact statistics because we're filing across the country, so no one actually tracks what is the chance of an I-129 petition denial being reversed by a federal court. And litigation is a relatively newer concept. We never really had to consider that because USCIS was a little more reasonable in their decision making before the Trump administration. But what I can say is definitely higher than 3%. You have a much better chance. You have a completely separate person. The AAO, even though it's a different office, it's still part of Homeland Security. So they generally are a rubber stamp to whatever the service center did. A judge is not. A judge is completely impartial, totally separate. They're going to look at what was before the officer at the time they made the decision, and is it arbitrary and capricious, or is it in line with the law? And if it's not in line with what the actual statute and regulations say, which many times it's not, they will overturn that or direct the Immigration Service to reopen the case.
When the percentage of denials was 2%, you still used to go for appeal, used to refile the application. Now percentage of denials have gone to 25% to 40% of the I-129s. It used to be expensive, I mean, for the litigation. is there anything that your office has done to cut down the cost on the litigation? Because litigation is an expensive process, especially federal court litigation. You're going in front of a judge that's appointed by the president of this country and is ratified by the Senate of this country. You're going to an independent judge, and he doesn't serve the president, he serves the justice. You're going in front of the judge. It's expensive. What have you done in your office to cut down the cost on it?
Yeah, it is very expensive. It does entail a lot of legal work to draft that complaint, and then, you know, if you're actually going and arguing before the judge, lots of motions are being filed and briefs and all of that. What we find is most of the time the litigation doesn't go very far, because once the lawsuit is filed, the government has 60 days to respond to that complaint. And many times, once they look into the situation, they realize that it's not a good case for them to argue. And rather than filing their response to the complaint, they just tell USCIS, reopen it and make another decision, which often ends up with an approval. So it cuts that alone, just that process, the procedure of it cuts out a lot of the later legal work that's normally part of a litigation. But we've been able to reduce the cost even further by grouping applications together that have the same reason for denial. So this could be within one company if they've received multiple denials. If we have a strong case, we can file one lawsuit for that one company on behalf of all of the petitions in one, rather than filing a separate lawsuit for every single petition. But even beyond that, if other employers received a similar denial on that same ground, we can group them in as well. And so we're in the process of grouping multiple employers together with their denials so that we can file one lawsuit and reduce everybody's costs.
One of the examples that I want to cite to people is that the specialty employer-employee relationship denials that we are noticing right now, the regulations are very clear with regards to what is an employer-employee relationship. According to the regulation, the employer must have right to hire, right to fire, and and the employer is obligated to pay the salary. These are the three conditions that the employer need to meet. Now, if the employer is not meeting these three conditions, there are or otherwise required, there are other conditions that the employer can meet. Now, the USCIS went on explained are other conditions where the employer controls the employee. They went into too much detail. But if you look into the regulations are very clear that hire, fire, and pay or otherwise control. It's or, but the USCIS is interpreting it as and, A-N-D. It's not, they're not interpreting as or. That's a clear regulation violation. And that is one of the most significant percentage of the denials are coming on the employer-employee relationship. At this point of time, this administration is not following the regulations that they passed. They are circumventing all the regulations, circumventing all the laws to get the denial. Looks like the only way in some of the cases, not all the cases I would say, is to go through the litigation process. Especially when we have gone to the H4 EAD litigation, we have been having good success rate in that. Our litigation counsel director, who is Jonathan Watson, has a good success rate in the H1B denials. So I think so that if the denial comes in with a 3% that you are giving in, I'm going to opt for litigation. Yes, it's going to be a little bit expensive, but I have a better chance of winning in this one than that of litigation. Emily, on the F1 OPT and some OPT stem extension denials, we're seeing a significant amount of denials, and some of those things can be easily avoidable. Can you give some of the tips to people what you have seen in practice where OPT stem extension gets denied that are very easy errors that can be avoided by the people?
Yeah, I think the number one problem is people wait till too close to the deadline to file. So when you are filing your I-765 with USCIS for either your initial OPT or your stem extension, please don't wait till the last minute, because there are sometimes delays in the mail getting delivered. If you mail it and it gets there on Saturday, they're not going to have it be received on Saturday. It's received on Monday. And if that's after your initial OPT has expired, you just lost your chance, and there's not really a way to overcome that. The other thing we're seeing is, for those that are waiting till the last minute to file, they are either filing with an I-20 that has expired. You need to know that the I-20 that authorizes your OPT is only valid for 30 days. So from the day it's printed out, it has that issue date on it, it's going to be signed by the DSO, and they hand it over to you. You have to have your I-765 reach USCIS within 30 days from that. And I've seen several situations where people were not aware of that 30-day deadline. They waited and filed after the 30 days, even though the I-765 application
has been filed in the proper timing.
Right, it was filed on time, but the I-20 had already expired by the time they filed it, and that could have been easily corrected.
When you say I-20 acquired, since the time the DSO endorsed it, the 983 thing, he endorses it.
The I-20 itself, when it's printed, it'll have a date on it.
Okay.
Don't go beyond 30 days from that. And then simple things like making sure it's filed at the right service center. Again, because people wait, they file accidentally at the wrong place. USCIS is not your friend. They are not going to forward your application to the right place. They're going to send it back to you. And when they send it back to you, it can take 2 weeks. And if now you've missed your deadline, they're not going to honor that original filing date, even if you filed everything correctly, just to the wrong place. So make sure you're filing it at the correct location. Make sure everything's perfect with the check, the actual check being paid to USCIS. The form, make sure every single box is checked. It's got to be filled out correctly. You miss checking a box, you miss a signature, they're not even going to accept it. They're going to reject the whole thing, mail it back to you, and if you filed towards your deadline, you're going to get it after your OPT expired or after the time period for you to file, and then it's too late. There's no way to overcome that. So most important thing is don't wait till the last minute to file your I-765, and be aware of that 30-day deadline.
And you need to file your STEM extension before your 765 expires. I'm sorry, before your OPT expires. So if your OPT expired, you filed it, you're gone. I mean, you have to keep note all these deadlines and speak with your DSO to make sure that everybody's in line, and make sure you don't, as Emily has pointed out, don't go to the end date. Emily, the new rule has come out today with regards to the 2021 quota, which starts on April 1st of 2020. And they said it's a $10 fees for making into the lottery system. Can you give more details how the employer can file the quota cases in April of 2020? What do they need to do if they have to file a quota case?
Let me check my crystal ball. We don't actually know. All we know is they previously finalized a regulation that allows them to conduct this electronic registration process. So sometime next year, we don't know when, assuming that they decide to use the electronic registration process. We don't know for sure that they are planning to. The company that intends to sponsor individuals for H-1B visas that are subject to the cap will log on to some electronic system.
Which we don't have it.
We don't have yet. They will fill in basic information about the employee.
Which we don't have.
We don't know what that is.
Looks like the movie where they're planning to go rob a bank and they don't have any idea what's there.
Exactly. So that rule has already been finalized, but we have no details about it. Now, tomorrow they're going to be proposing a new regulation that modifies the prior one that was finalized to create a $10 registration fee for each individual that the company registers. That's all it says is, we want to create this $10 fee, and here's why. This will cover the cost of the system and hopefully reduce fraud. They give no information at all about how you'll pay the $10 fee, who has to pay it. Is the company going to have to sit there with their credit card? And what if they're planning on filing 100 H-1B petitions? Are they going to have to click pay now 100 different times like they're out checking out on Amazon?
No,
or is it going to be just one?
Our bank is going to reject it
Yeah.
because when you see more payments of $10 things.
Yeah, can you do a wire? Does it ACH? I mean, we're not talking about small companies here. Large companies use this program, and we have no idea how they plan on implementing this, and we are already into September. Now, we normally start preparing these cases in January. Now, the comment period for this new $10 fee proposal is for the next 30 days. Normally, a comment period is 60 days, but they said because they're planning on implementing this for next year, they're going to shorten the comment period due to the time pressure. So it does appear that they're still on board for doing this in April 2020, but we have zero details about what it's going to actually look like.
Yeah, subscribe or like the video, and click on the bell icon on YouTube, and we will update you guys in the coming episodes that we have on how the things will turn out on the lottery system. Emily, moving on to the last action rule. What is this last action rule? I'm on H4, I file the H4 extension, I file the H1, and then now H1 gets approved, now H4 gets approved. It's all, can you explain what a last action rule is?
Yeah, the idea behind it is, when you've got multiple things going on, the last action or the last I-94 issued is the one that...
The last means the last or the recent
one? The most recent.
So that last means the most recent.
Yeah. So perfect example is someone who's currently in H-1B status. They file an H-1B extension and they're worried that it might get denied given the new environment that we're in. So as a backup plan, they decide to also file a change of status to H4 and an H4 EAD because their spouse is in H-1B status and has an approved I-140. So now they have a pending H-1B and a pending H4 and H4 EAD, and then the H-1B gets approved, and then the H4 gets approved, and the EAD gets approved. So what status are they in that situation? The last action, the most recently issued I-94, is going to be the H4. So even though the only purpose of filing that H4 was a backup plan, because you were afraid the H-1B was getting denied, you got the H-1B approved, and now you're in H4 status whether you want to be or not. And what some people get confused about is they think, well, I want to go back to H-1B status, or I don't need this H4, I'm just going to withdraw it.
Oh.
Don't do that. The withdrawal is going to put you out of status. It doesn't put you back in the previous status. So to clear that up, you often have to travel, use automatic revalidation or something like that. But it's becoming more and more common these days for people to have multiple things pending just so they have a backup plan. But that can create a lot of confusion about what status you're ultimately in when you get a bunch of approvals.
Yeah, when you get a bunch of approval, don't just withdraw the application. Make sure that you consult with a lawyer. As Emily has pointed out, there is something called automatic revalidation. You may want to consider or speak with a lawyer before you do that. Just please don't withdraw it, because if you withdraw it, you may be out of status.
One thing that we're seeing quite often right now as well is this idea of short-term H-1B approvals. So if you file a transfer or an extension or even an amendment, and you're requesting a 3-year period and you're eligible for 3 years, randomly we get an approval for 6 months or 1 year or 3 months or 18 months.
I even got 1 day.
Yeah, it's very random. So what are the options when that happens?
The legal rule is that when the USCIS is going to deny your application, they are supposed to give an explanation. When you're asking for a 3-year extension or 3-year transfer plus extension, when they are giving in a shorter period of time, they are supposed to give an explanation. You asked for 3 years, you are not eligible for 3 years because either you had used up 4 years of H-1B, you're only eligible for 2 years of H-1B, rest of the 1 year we deny. They have supposed to give an explanation to that thing. Now, we have seen people, USCIS giving 2 years, 1 year, 1 day. Sometimes the approval comes on September 3rd, but the approval is only until August 15th. and they're not giving any reason whatsoever at all. That is a complete violation of Administrative Practices Act, rules passed by their own government, rules passed by, they are not following the rules passed by them. And these shortened approvals, they should give an explanation. I know that we've been giving explanations to our clients saying, look, your statement of work or your end client letter doesn't prescribe a particular date, so the officer picked whatever date he want to, or pick the shortest period of date among all the letters, vendor letter, employer, end client letter, MSA, SOW. He can, some of these USCIS are picking up whatever date they want to, but they're not giving any explanation whatsoever at all. It's a complete violation of the regulations that they have passed. I think so that if there is a shortened approval, we go to court, we have good chances of getting the approval on simple technical thing because they didn't give us explanation. When they are giving a shortened approval, they are supposed to give us, we requested for 3 years, you only gave us 1 year. You didn't give us any explanation. That is enough for these things to get stricken by the court. I think so when we go to the court, which we are filing a litigation coming this month, we are filing a bunch of shortened approvals. If anybody wants to join, you can contact our office, is going on one technical ground itself, is that you are not, USCIS is not giving any explanation whatsoever at all when they are denying our full 3 years of H-1B. So that's a good ground for us to go and win the case. We have good possibilities for it when we win the litigation.
So why would you choose to go to the court for that versus, you know, if you get a 6-month extension, just turn around and file another extension?
Well, when we turn around and file another extension, one, I always want to get a results by faster before the I-94 expires. Even if I'm filing an extension, they're going to be 6 months extension. Then I'm filing for 6 more months. It's a very lengthy process sometimes, premium processing, the cost of HR, the filing fees, the stress. They don't get the driving license every time they have to renew the driving license. The H4 EADs don't get renewal on the proper timings. To avoid all these things, litigation is the best source, and it probably will fall cheaper because you are clubbing all the applications together. We are clubbing all the applications together. It's probably work out cheaper than filing multiple extension. I mean, I have kids, people have kids going to school. They don't know whether they can stay here for the next 6 months or not. They need to have certain certainty. Well, if I'm not going to stay here, at least I can go to my home country. At least I need to stay until the kids' education is over this academic year. I'm not speaking about a couple of years. So for all these certainties, I think so litigation is the only source. They're technically violating the law. It's a good thing to go. I'm pretty positive that we should be able to win all these cases. Emily, let's go to questions, live questions on YouTube and Facebook that we have. Facebook, we are getting the question from Arvindam. How do you predict the EB1 coming next year? That means starting from October of 2019. We are not predicting EB1 to be moving much faster. One of the major problems with the EB1, Arvindam, is that the other countries have started backlogging on EB1. Now what happens is that when all the quota gets filled out, any country that's taking more than 7% will get cut off. So India got cut off right now on the EB1. Previously, a lot of other countries were not using that 40,000 that's been allocated. So the green cards that were going waste were actually being given to mostly Indian nationals and Chinese nationals. And now the other nations are using more EB1. So Indian nationals are getting just 7%, which is 2,800, a little bit more than that sometimes, the leftover by the other countries. So out of those 2,800, it's Mr. and Mrs. So only 1,400 families approximately are getting an EB1. There's too much demand. We are not expecting much movement in EB1. And I also have a question from Kiran for EB2 predictions. It's the same thing. We're not expecting much movement in EB2. To cross the May of 2010, it might take a long time unless the S386 bill, the Senate bill on taking the per country quota limit has been taken off.
All right, question from YouTube from Navdeep. Without leaving the U.S., how can I extend my I-94 after my passport is renewed? It's a very common issue for someone who has received a extension approval notice, traveled, is coming back into the U.S., and their passport expires before the approval notice expires. They're giving a shortened I-94 at the port of entry in line with the passport expiration, not the I-797 expiration. So to do that without leaving the U.S., you have two options. Option number one is file another extension with USCIS, which is not a great option because now you're paying filing fees again and more uncertainty again. There's no guarantees that they'll approve it this time around. You might have to go through a request for evidence again, even though you just got the approval earlier. The other option, which seems to be working less and less, is go to deferred inspection, which is a CBP office where they will correct I-94s. Now, in the last few years, they are less and less likely to do this because they don't treat it, it's not seen as a correction needed. The I-94 was properly cut short because your passport was expiring. So usually CBP doesn't do it anymore. So really the only way to get it extended is to file an extension. But that's usually not the best option. It may be a better option to use automatic revalidation to travel to Canada or Mexico and come back in, or you have to go for stamping again if you don't qualify for that.
Emily, I want your attention on this. Santosh from YouTube has this question that he is from University of Wilmington University, and they are not giving the 983 endorsement for third-party location, though on the ICE website, after our litigation director Jonathan Watson has sued ICE and reversed, and they changed their online thing where they said that third-party working is allowed, but this one particular university, Wilmington University, is not authorizing to give the STEM OPT.
Yeah, even though the website was changed, at one point the USCIS website randomly updated to say no third-party placement was allowed on the STEM OPT, which is not what the regulations say. We were part of the litigation that sought to correct that, and they did pull that part of the website down, and now it just goes back to what the regulation says. So the regulation says that third-party placement situations may not be appropriate for STEM OPT because of the potential lack of supervision, but they give the opportunity, if you can show that there's a bona fide employer-employee relationship, then it still qualifies. Now, the question is this university saying that there's no bona fide employer-employee relationship and therefore they're not allowing it, or are they just going based off from the old website update and assuming that no third-party placement is allowed? So it may be necessary to have an attorney contact the DSO to further understand why it is that they're denying this. This happened a lot when the I-983 first came out. We saw the same issue. Our office had reached out to several schools on behalf of clients and were able to explain to them how this particular situation qualified, but not every third-party placement qualifies.
Yeah, you have to convince your university that that you are a third-party location, but you're getting controlled by your employer to satisfy all the requirement. But we did notice that the DSO from the Wilmington University is not willing to listen at all. I mean, that's what I would request, that you contact a lawyer to have them write a letter to make sure that you are complying with the 983 and they should be giving you the 983. I would recommend that you can team up together with all the students and then come and contact a lawyer, because this might take a little prolonged way of getting the 983 endorsed by this Wilmington University. Out of all the universities that are, thousands of universities that are eligible for STEM extension, I only find this one particular university that is giving trouble at this point of time.
Ratika from Facebook has a question. She's currently on H4 with an H4 EAD. She also applied for an H1B and got it approved after an RFE. The H1B is only valid approved until February 2020, and she wants to know which status she's actually in. So this is kind of a combination of our discussion on short-term H1B approvals and the last action rule. So in this situation, the H1B has not actually kicked in yet. So even though that is the most recently issued I-94, it hasn't taken effect, and it won't take effect till October 1st. And I'm assuming that your H1B was approved with the change of status and has a new I-94 on it. So on October 1st, you're going to automatically change to H1B status, and you can only stay in work for 5 months until February 2020. So at that point, your employer needs to file an extension of the H1B or consider joining in the litigation to get the full 3-year period that they've applied for. But at this moment, you're still in H4 status. On October 1st, you'll magically be in H1B status unless you go out of the country and come back in after October 1st in H4 status again, if you want to undo your change of status.
S. Iyer has this question from YouTube. He or she has completed 6 years of H1B, now on H4 EAD. Can an employer file a H1B in the new April? No. For your company to file a H1B in the new quota, you must be outside the country for at least 1 year. But I have an easy solution for you. You are on H4 EAD. You can have your employer file an I-140 approval, and once you have the I-140 approval, you can file the H1B extension. Not a problem. You don't have to go with the new quota. One more time, on H4 EAD, you can file an I-140. Once the I-140 is approved, you could get the H1 extension.
Anurag from Facebook just received his H1B extension approval, but has not received his wife's H4 extension. Join the club. That's where everyone is these days. But he wants to know if his wife can travel to India and get the H4 stamp, and how does the I-94 work in that situation. So yes, she absolutely can do that. Probably going to be your faster option at this point. She'll apply for the H4 stamp using your new H1B approval notice. When she comes back into the U.S. at the port of entry, that's when she's going to get the new I-94. She has to go online and print it out from the CBP website. So instead of getting the I-94 sent on an H4 I-797 approval notice, she's going to get her I-94 from the online system through the CBP website after she enters.
Pradeep has this question on the YouTube. Can litigation be filed when the H4 plus EAD is pending for more than 30 days? Yes, we have been there. We have been very successful. Past success is not a guarantee for future success, but as of now, we did very good where the H4 plus EAD has been pending for more than 30 days. One caveat is that the H1B underlying H1B must have been approved, and even if it's approved recently, that's fine. It doesn't have to be approved for more than 30 days. We could file a litigation, and we've been very successful in it.
Manohar from YouTube has an approved I-140, and it's been approved for more than 6 months. He's considering moving back to his home country. Wants to know if in the future he can visit to the U.S. on a B1 or B2 to attend conferences or come in as a visitor.
Good question.
Yeah, it's a really good question. So anytime you're applying for a B1 or B2 visa at the consulate or entering in B1 or B2 status at the port of entry, you always have to demonstrate your non-immigrant intent. That is, that you're only intending to come here temporarily for the purpose of visitor or business, and that you intend to return to your home country at the end of your temporary stay. The problem is, an I-140 is the exact opposite. That I-140 is an immigrant petition. Having an approved I-140 clearly demonstrates that you have immigrant intent, so you may end up not being able to get the B1 or B2 visa stamp. Even if you do get it, you could be denied entry at the port of entry because you have immigrant intent.
Yeah, it's you just have to satisfy that even though you may have an intent, this particular trip, what you're doing, is a temporary trip.
Sunil from YouTube, going back to the OPT issue, wants to know if you can work from home while on OPT, and says there is a legitimate training program, and he reports directly to the manager. So again, the I-983 just requires that there be a bona fide employer-employee relationship and that there be sufficient means to carry out the training and for you to receive that training. So there's nothing in the regulation that prohibits working from home. Again, it's going to be up to the DSO in endorsing that I-983 form, but there's nothing automatically wrong about working from home while on OPT. I'm assuming this is during the STEM extension. During the initial OPT, there's no issues with that at all.
Yamini has this question: can I have travel on advance parole after RFE? I'm assuming that you're speaking about the 485 RFE. I would advise not to, because if there is any denial or anything like that, it may cause a problem. I'm assuming that you already have the advance parole. But still, based on the RFE, if it's a simple medical and you're just submitting the medical report, then I'm fine with you traveling. If it's something core to the 485, then you need to make sure you don't travel while the RFE is there.
Niti from Facebook wants to know how early I should file the H-1B renewal when it's coming up in 2020. So the H-1B renewal, the earliest you can file it is 180 days before it is set to expire. And as close to that as possible is the best idea. That way, if something were to go wrong, you have plenty of time to respond to an RFE, plenty of time if it gets denied, you have enough time remaining to just refile or potentially seek litigation as a way to reopen that denial. So the earliest is 180 days, and as close to that as possible is a good idea, especially if you have a spouse with an H4 and EAD that needs to file their extension, because that's taking longer.
Niti from Facebook has this question that her H-1B is expiring in 2020. What is the best time to file for H-1B? Well, ideally, the best time would be 6 months before your H-1B expires. But as we have noticed that when the SOW, MSAs, and client letters have dates that are shortened period, that may endanger you to get a H-1B approval for a much shorter period of time. So you may want to consider waiting until you get the contract renewed and file an extension. But one thing I can tell you is that try to get the approval way before your I-94 expires and in premium process. The reason is that if by any chance you get the denial, you will have an option to file one more extension, you have an option to file a transfer, you will have an option to transfer to different visa status if it's possible.
Saptarshi from YouTube wants to know what happens if the H-1B gets denied and the I-94 already expired 180 days ago. Is there going to be a bar to re-entering the U.S.? And that's a great question, because there is a 180-day rule where if you have 180 days or more of unlawful presence, it creates a 3-year bar. However, that's not applicable in the situation where you timely filed your H-1B extension. Once it was timely filed, meaning before your I-94 expired, there's no unlawful presence. It is tolled during the entire period while your H-1B extension is pending, even after your I-94 expires. So if your H-1B extension ultimately gets denied and your I-94 expired 6 months ago, that doesn't count. It only starts counting from the day after the denial was issued. That's when you start counting the 180 days. So there would be no bar in that situation unless you stay another 180 days after the denial, which would not be a good idea.
Murli has this question from Facebook. Is NIW EB2 faster to get the green card than the regular EB2 employment sponsor? No, it's the same. It still comes under EB2. It's going to take good number of years. You already know the time it takes for EB2. When does NIW become an advantage is that when the employer is not willing to file your application, if you're eligible for national interest waiver, you could file a national interest waiver by yourself without involving your employer. That's when NIW becomes a very useful tool.
Conda Reddy from YouTube has a question. How risky is it to go from H1B to F1? So this is something that several years ago was kind of a common practice, very simple,
yeah.
Especially during the recession. A lot of people switched to F1 status to study during that time. Nowadays, not so simple, lots of risk involved, and that's mainly because of the processing time of the I-539. So to file a change of status from H1 to F1 can take up to a year or more for the I-539 to be processed, and you have to continue to maintain your H1B status that whole time it's pending, which is different from filing other types of change of status. So because of the long processing time, there's definitely a risk that something will go wrong with that in the start date of the program constantly being changed. Visa stamping also could be problematic because just like I talked about with the B1 and B2, that you have to prove your non-immigrant intent when you're going for stamping, the F1 is the same thing. So if you've already been here for several years on H1B and working, you may have a difficult time proving to a consular officer that now your stay is only temporary for you to study. So it's not that simple to go from H1 to F1 at this stage.
Pranav has this question: is biometrics required for all H4? Pranav, there is no biometrics for EAD, but there is biometrics required for H4. If you're filing an I-539 application, you have to do the biometrics. Biometrics are required not only for the spouse, but it's also required for even if the kid is 2 years old. We still need to have their biometrics taken before they're given the H4 extensions.
Anam from YouTube has a question. The I-485 interview happened more than 90 days ago and no answer has been received from USCIS at this point. What can you do? Well, assuming your priority date remains current, the next step would be to submit a service request for outside normal processing time and see what comes from that. You also have the option of contacting your senator's office or congressman's office for assistance with a federal agency to try to get the case moving again.
Question is that I have my I-140 approved. I'm applying for Australian PR, permanent residency. If approved, if I become an Australian citizen, what happens to your I-140? Assuming if your I-140 has been approved for more than 6 months and it's not yet been withdrawn, that I-140 priority date belongs to you. So if you become an Australian citizen, you can always come back on H1B if you are on H1B right now, or you can use the I-140 priority date at any later time for you to immigrate into the United States when your priority date becomes current, especially when you have another employer who's willing to file an I-140 and put the date to your. So that I-140 priority date will belong to you even though you become an Australian citizen. You can always use it at a later time.
Vivek from YouTube has a good question. He wants to know what the timeline is. I'm guessing that's for an L1A extension. And the important question is, his application was filed to the Texas Service Center where processing times are saying 6 to 8 months, but the Vermont Service Center is saying only 2 to 4 months. Can I change the service center? Unfortunately, you cannot. The service centers are where your case goes is determined based on where the company is located, and you can't file at a different service center for any reason. They will not accept that. So unfortunately, you're stuck with that processing time.
Vijay Kumar has this interesting question on the follow-up from H1 to F1. Is there any policy change came to the maintenance of status? From H1 to F1, there is no policy change on the maintenance of status. It's been the same, nothing has been. But the problem here is that the USCIS started delaying the F1 cases. Previously, F1s used to be adjudicated in 2 to 3 months. Now it's taking anywhere between 12 months to even 24 months. And that's a problem. You have to maintain your legal status until you get the F1 approval, actually 30 days before you get the F1 approval. So if it takes about 18 months, you have to maintain the legal status until 17 months. That becomes a problem because you have to continue getting paid on the H1B, otherwise you're not maintaining the status.
Bubbles from YouTube wants to know if it's mandatory to apply for the H4 EAD extension before it expires. So I'm assuming you're talking about just the EAD, not the H4 itself. So an EAD, you don't have to apply for it before it expires. As long as you're maintaining your H4 status and your spouse has the approved I-140, you can file the EAD at any time. If you're talking about the H4 along with it, then definitely yes, you need to maintain your H4 status. So the H4 does have to be filed before the previous one expires.
Shravan has this question. What is the maximum limit that the person can work on a receipt notice with a new employer? There's no maximum limit. There's no 240-day rule. If you're moving from company A to company B, you can continue working even after your I-94 expires. There is no maximum days. You can continue until the H1 is adjudicated.
Sravanan from YouTube wants to know his spouse is working on H4 EAD that's expiring in December. The H4 EAD extension and the H1 are in progress, and he wants to know if she can continue working on the H4 EAD while it is pending. Well, I guess I'm not really sure of the question, but I'm going to say, assuming the question is, can you continue working on the H4 EAD while it's in progress? The answer is no. If you don't have the new H4 EAD approved, then you have to stop working.
But if the validity period of your previous H4 EAD is still there, let's say, for example, if your EAD is expiring in December and you're filing an extension, you can only work until December, until the EAD expires. Once the EAD expires, you cannot continue working unless you receive the EAD approval.
Yogesh from YouTube has a good question. Does the I-140 need to be refiled if there is a residential location change from one state to another? So the I-140 filing is the company's filing. So if you have moved but the company has not, then no. And it's also based on wherever the job was located that your labor certification is filed for. So if that job remains in the same place, even if you moved, it does not impact your I-140 and nothing needs to be filed or refiled there. If the job itself that you were sponsored for moves out of state, then yes, a new labor certification very likely is going to be required, and then a new I-140 after that.
Naga has this question from Facebook. I have completed my MBA, got my OPT. The MBA is a non-STEM thing. I'm not eligible for the 2-year STEM OPT extension. If I do a second master's degree, would I be getting the STEM extension? The answer is no. Here is the reason why it's no. If your OPT, you are only allowed to get one OPT in one level of degree. Since you already completed the MBA, and if you're going to do another master's, it's the same level of degree. In the same level of degree, you can't get 2 OPTs, and you can't get a STEM extension unless you are on OPT. So you lost that opportunity of getting the STEM extension. The only other option you would have, if you have not used up the 1-year OPT, is at the MBA level, you don't get an OPT at all, then you go join another master's, then get an OPT. At that point of time you would be. But since you already used the OPT, you can't get another OPT at the same master's level. Without another OPT, you can't get a STEM extension.
Jignesh from Facebook wants to know how safe it is to apply for an H-1B transfer to another employer after October 1st. So I'm going to assume that your first H-1B is a cap H-1B and is approved beginning October 1st, and you're looking at the option of transferring after October 1st. It is, there's nothing that's safe, 100% safe in immigration right now. Generally, when filing a transfer, if you have the option, we would recommend that you stay with your current employer until the transfer is approved and file that transfer in premium processing. Then you can safely switch to the new employer, because transfers can get denied. Just because you got the approval with the first employer doesn't mean you will with the second. So that's one thing to think about. And then it also depends a little bit on the specifics of the situation. You know, if you're talking about you had filed multiple H-1Bs in the lottery, one with your actual employer and one with some other side employer that has an in-house project for you and all of these things, and they'll give you a job after you get the approval, and that's the approval you got and you're looking to transfer to your actual employer, that's a completely different story that may not be safe to do, because we've recommended from the very beginning, don't file with these companies that offer you these in-house jobs for consulting companies, and they'll get you a job after you get the approval.
Public charge for the citizen kids. It's evolving law at this point of time. If the kids are taking any of the public benefits, I would recommend that you consult a lawyer right now. Even though if you're a H-1B and your kids are citizens, don't take any public benefits without consult a lawyer. They have passed the new regulations and they're modifying it, they're implementing it, so it's more testing grounds right now. Everything what you're going to take from the government, you have to check with a lawyer before you do any of that. A question comes from Murali Krishna. Can I do litigation because I got the H-1B shortened with another attorney other than the employer's lawyer? Yes, Murali, you can do the litigation. However, one caution that I would tell you, Murali, is that your employer has to cooperate with the litigation lawyer. You cannot by yourself do the litigation on the H-1B shorter duration. You have to request your employer to cooperate with you in getting the short-term extension litigation, and we intend to file one group of litigation this month.
Kenan from Facebook, his wife has H4 EAD right now, and she was on the H-1B previously with an approved I-140. She wants to know if she can switch back to H-1B in a cap exempt situation, since she's had the I-140 for more than 180 days, even if the employer withdrew. That answer is yes. The I-140 remains valid for purposes of getting H-1B extensions beyond the 6-year limit, and that can include a change of status from an H-4 back to H-1B without going through the lottery.
Vivek has this question from YouTube. His employer is not applying for EB1. He's an L1A. What should he do? Should he apply for EB2 on L1A? Can he apply EB2 on L1A? The answer to the question, Vivek, is yes. You can apply for EB2 on L1A, but what good is it going to do for you if you're going to do, because you can't extend it beyond 7 years. So I would recommend that you go ahead and apply for EB2 green card application. At the same time, try to convert into H-1B visa, because if you convert into H-1B visa, you can extend it beyond 7 years.
All right, I think we're about done for the day.
Thank you guys for joining our weekly immigration news. And if you have any questions, don't hesitate to contact us. You can make an appointment with me, Emily, or any of our colleagues at rnlawgroup.com, or you can even send an email to info@rnlawgroup.com. Don't forget to subscribe subscribe to immigrationgirl.com, which Emily manages as a blog.
Thanks for joining. We'll see you next week.
Thank you, guys.